Hi everyone. So let's have a look at the current affairs for this week. So National Commission for Minorities. This news has been surfaced in the backdrop of the recent appointment of the chairman for National Commission for Minorities, and this post has been filled after 15 months of being vacant. Harjeet Singh Garewal has been appointed as the new chairman for the National Commission for Minorities. Now let's look at the commission itself. What is National Commission of Minorities and when it had been established? So first of all, it is a statutory organization. That means it has been established after an act of parliament in 1992 and it came fully into force in 1993. What is the basic purpose of this act? Is to protect the minority rights, monitor the constitutional safeguards and look into the advices given by central and state government and thereby implementing them. Now, there are basically 6 religious minorities that has been identified by this commission, wherein the Jain has been incorporated in 2014 only. So let's look at the chronology of this commission. So evolution, how it has been evolved. So first of all, in 1978, by resolution done by Ministry of Home Affairs, it was established, and then by a proper act of the parliament, it was incorporated in 1992 and it became fully functional in 1993. It had its own commission, it had its own office and staff. So what is there for UPSC is, the constitution does not define the term minority, right? Religious minorities are notified by the central government under the act of NCM Act 1992. And there are certain constitutional safeguards that have been provided for the minorities, starting from Article 14, right to equality, Article 15, prohibition of discrimination, then Article 16 gives the employment equality to everybody, and then Article 29 protects the interests of minorities, which protects basically the language, script and culture of the minorities. No citizen shall be denied admission to any organization, any government funded educational institution on the grounds of religion, race, caste, language and any of them. Then comes Article 30. Article 30 talks of the rights of minorities to establish and administer educational institutions. Under this act, the minorities, they have been given certain autonomy and independence so that they can operate in their respective spheres. Then Article 347 talks of the recognition of minority language. If a substantial proportion of the population in any of the state speaks one particular language, then the president, he can thereby direct the recognition of that particular language. Then Article 350, what does it talks about? It talks about the establishment of a special officer for linguistic minorities, which says that the president shall appoint a special officer for linguistic minorities to investigate the matters related to the safeguarding of the linguistic minorities and submit report thereafter. Now Article 350A, what it is all about? It recognizes the mother tongue instruction at the primary level, that it is the duty of the state and the institutions to give instructions to the children at primary level at their mother tongue. So Article 350B, it establishes a provision which empowers the parliament. Here the term parliament is there. Please try to remember where president is there and where parliament word is there. So it empowers the parliament for effective implementation of the above safeguards. So all these rights, all these articles, they have been given for the minorities. They have been safeguarded by the constitution. Let's look at the composition, appointment, tenure and powers. First of all, it contains one chairman, vice chairperson and 5 other members. right? At least 5 members out of all these members must belong to the minority communities, right? Appointment is done by the central government. The term of office of the chairperson, vice chairperson and the members is for 3 years. However, we have seen there was a vacancy for like good 15 months and now Harjeet Singh Garewal has been appointed as the new chairperson for the National Commission on Minorities. So what are the powers of this commission basically? First of all, it can summon and enforce the attendance of any person, right? Then it can examine any person on the basis of oath. It can also receive evidences wherever it thinks there is a requirement of the evidence. So it can ask the relevant authority or person to furnish the evidences. Requisition on any public record or any copy of thereafter, it can also be asked. Then it can issue commissions for the examination of the witnesses. Then any other matter which may be prescribed under the act can be taken over by the commission. What is the nature of the National Commission on Minorities? First of all, it is a statutory body. That means it has been established by an act of Parliament. UPSC usually asks questions based on constitutional body and statutory body. Constitutional body is which is mentioned in the Constitution of India and statutory is which has been established by an act of Parliament. Thus, NCM is not a constitutional body. Then its recommendations are not binding. Basically, these are the challenges that are being discussed in this regard, that it is a toothless tiger. It does not have much powers of its own. It is just a recommendatory body and that too faces issues of regular vacant seats that are there in this commission. So functions of NCM, it works as the watchdog, advisor and catalyst for the minority rights and welfare. There has to be a dedicated body which can take care of the dedicated interests of the religious minorities that are there. And I'm again reiterating that the term minority is nowhere defined in the Constitution of India. And we have identified so far 6 religious minorities, wherein the Jain minority, the Jain religious minority is the latest one. So functions, first of all, it evaluates the development of the minorities. The development plans, basically it takes into account how much developments are being done. Socio-economic and educational development ka we are referring to here. Then it monitors the constitutional and legal safeguards that are being provided by the Constitution to these minorities, whether they are being adhered to or not. It looks after the functioning of constitutional matters. Then recommended measures. It can recommend the welfare schemes, welfare measures with regards to the minorities and their effective implementation. It also has to ensure its effective implementation. Whatever directions this commission gives for the welfare of the people, so they need to be effectively implemented. Then it can inquire into complaints that are that this commission receives basically. So it inquires into specific complaints regarding deprivation of rights. If any minority feels that at any point of time their rights are being infringed or violated, so they can approach to this minority welfare minority commission and then it can look into the matter and suggest the relevant remedy. Then conduct studies and research. So it conducts studies and research on socio-economic conditions of the minorities and what is their status with regards to education and the problems that they are facing in exercising their rights. Also, it has the power to suggest the welfare measures wherever it thinks fit and take initiatives for the upliftment of the minorities, right? Then it can also submit reports which are annually submitted usually and special reports to the central government on the working of the safeguards and the welfare measures. What is the reporting mechanism basically of this commission? So NCM submits reports. First of all, they are being laid in the parliament and the respective state legislatures. Then discussions are being held and the necessary actions are being taken thereafter after due discussion and deliberation in the parliament. So this is how the functioning of this commission is being done. Then there are certain challenges that this commission faces. What are the major challenges? First of all, limited enforcement powers. Like I told you, it is like a toothless tiger. It can only recommend measures. It does not have enforceability powers, right? So it can just recommend the provisions. It is simply a recommendatory body, and the recommendations are not binding on the government. Then vacancies and staffing shortages. Time and again we see there are vacancies which are like already there in the commission. Even now the chairman who is being elected, he has been selected after 15 months of long vacancy. So this is a major challenge. Then weak coordination between the central government, state governments and this commission. So there is no robust planning and implementation of the suggestions that are being suggested by this commission. Then low research capacity. Due to resource constraints, due to financial constraints, due to manpower constraints, this commission is not able to research in a proper manner at micro level, right? There are technology gaps. The technology is still obsolete. They have to rely on the conventional methods. So, and case pendencies are there. Time and again there are atrocities that are being committed on the religious minorities, and due to this the cases, they keep on increasing. Now how can we reform the commission? How can we make it better? First of all, we need to strengthen the state commissions which operate at local level, which operate at state level basically. Then there has to be some digital complaint mechanism where whereby the citizens or the aggrieved citizens basically, they can have on tap availability of the remedy, and that is possible when we can just launch a measure wherein there is a digital complaint management system. Then outcome based performance monitoring should be there. There has to be certain, you can say, indicators jisse ki we can measure the performance of the commission, and it has to be reviewed periodically and suggest the necessary changes that are required. Then it requires some funding for research. It does not have much resources, that is why they lack some sort of data and people are left like that. Then improve accountability and transparency. Timely disclosure of reports, status of recommendations and follow-up actions, they need to be at place in time, right? And faster grievance redressal mechanism. Justice should not be delayed at any cost. So strict timelines must be there and proper redressal mechanism should be there. This was about National Commission for Minorities. So what is the way forward basically? A strong and credible NCM can build trust, reduce alienation and promote equal opportunity and inclusive governance, which the Constitution also talks about. So to uphold the constitutional morality, we need to keep this commission robust. Now the next news is about the new vaccine that has been developed for dengue. The name is Qdenga TAC-003. The name itself is suggesting that it is some sort of Japanese name. So yes, it has been manufactured by a Japanese company only. However, it is developed in India. It is approved in India. So the name is Qdenga TAC-003. Now, who is the authority to approve the medicine? It is Central Drug Standard Control Organization, which comes under the organization, under the body, that is DGCI, right? Then which all age groups have been targeted for this medicine? We have tried to cover almost all the age groups starting from 4 to 60 years, and there are 2 doses that are suggested for this medicine, which are to be taken at 3 months interval level, right? So 3 months mein 2 doses would be given in the age group of 4 to 60 years. Then it has been developed by a Japanese company called Takeda, right? And then it contains live attenuated tetravalent vaccine. Live attenuated tetravalent vaccine means it contains live virus. However, the intensity is reduced. Just try to understand it like there is a lion but the claws and the teeth have been taken away. It is still a lion. So it is impactful, however, the intensity is reduced. The live virus is injected into the body, which builds the antibodies against the virus. So, and tetravalent means that it is it is helpful for the all 4 varieties of dengue. That is why the name tetravalent vaccine is given, and it is already WHO pre-qualified. So what is dengue? First of all, how dengue is caused? Female Aedes aegypti mosquito. This is the vector behind the spread of dengue. There are 4 serotypes, like I told you. That is why this medicine is called tetravalent, which is helpful for all the 4 serotypes of dengue. Now, how it is infected? If infection is by one serotype, then lifelong immunity is there against that serotype only. However, this vaccine covers all the 4 serotypes collectively. So that's a win-win situation. Then secondary infection can also be there, much important. Then dengue fever. What is the symptom of dengue? Sudden high fever is there, headache is there, then retroorbital pain is there, melangia rash and joint pain is there. If it is a severe dengue, then what are the symptoms? Severe plasma leakage could be there, bleeding, then organ impairment and shock. So many vulnerable groups are there for dengue. They are primarily children, elderly people and pregnant women. People with comorbidity are also more infected than the normal people out there. So you need to learn the name of this, you need to remember the name of this medicine, and it is not indigenously made. Please try to understand the difference. It is approved for indigenous use. However, it is not indigenously made. It is made by Japanese company only. So we should know the difference. Like COVID vaccine was also not manufactured indigenously. It was approved only. So what are the major challenges? First of all, there are 4 serotypes. So we need to make sure that the vaccine works for all the serotypes, and that is why the name is tetravalent. Then antibody dependent enhancement. So let's try to understand this. What is antibody dependent enhancement? For instance, there is a thief who comes to your house. So that guard recognizes that thief once, right? And it has a picture of that thief. Then if again that thief enters, the guard would be cautious. The guard is the vaccine and the thief is the virus basically. Now what happens if there is second kind of thief that enters your house? Then the guard may not be able to recognize it. Then it can enter your body. It is a thief only. So that is the different serotype that can enter your body and which can cause harm to you, which can cause ultimately dengue to you. So this is what antibody dependence enhancement means. So long lasting immunity is needed. Somebody who is low on immunity may not be able to take the best of the medicine. Then variability in populations. We have wide range of population with different age groups, different genders are there, different nutritious level are there, different allergies are there, different comorbidities are there. Therefore, we need to keep in mind the diversity of the population. Then there are certain safety concerns that also come with the new vaccine, and that is the live vaccines carry risk of reactogenicity and require extensive trials. Yes, there has been trial on around 28,000 people already beforehand, and then it has been incorporated. So how Qdenga addresses these challenges? First of all, it is tetravalent. Like I told you, it is helpful against all the 4 serotypes. Then live attenuated platform has been given, live virus has been injected, durable immune response system, that is long lasting immunity it basically provides. Then it caters to wide range of population that is there in our country. Extensive tests have been done beforehand and it is safe for human use. So this was about dengue. क्यों देगा? So a quick revision of whatever we have done so far for your prelims. Scientific name of this medicine is TAC 003 or Qdenga. It is developed by Japanese company Takeda Pharmaceutical Company Limited. Then Japan has developed it. What type of vaccine it is? Live attenuated vaccine. Then nature is of course tetravalent. Technology is rDNA. Then 4 to 60 years of age group के लिए it is helpful. Then WHO status already pre-qualified by WHO. Approved in India, yes, by CDS CSO. What is the vaccine schedule? 2 doses would be given at 3 months of interval, right? How it works, not much important for UPSC. This much depth is usually not asked with regards to UPSC. Now we come to right to protest, constitutional framework and the legal limitations. So this right has been in news due to the backdrop of the protests that have been organized by CJP, wherein the government used the immediate action on the protesters. So that is why it is being contested. There has to be a balance between the rights of citizens and the government's immediate action on it. So let's look at the news basically. So what is right to protest? The citizens, they have the right to protest. They have the right to express their dissent, assemble peacefully and voice their opinions to influence the government and its policies. Under Article 19, which is right to freedom, we have been given certain fundamental rights like right to freedom of speech and expression, right to freedom of assembly, right to freedom of forming associations and things like that. So under these rights only, those protesters, they have been gathered at Jantar Mantar in Delhi. Now what is the purpose of all these rights? Right to freedom ka kya purpose hai? First of all, it expresses public opinion. If people have any people can express their dissent or suggest necessary policy actions or express their grievances. They can hold the government accountable for all the results basically. It protects the democratic values and it influences the public policy. So Article 19(1)(a) talks of right to freedom of speech and expression. Article 19(1)(b) talks of freedom to assemble peacefully without arms. And 19(1)(c) says right to form associations and unions. And Article 21 deals with right to life and personal liberty. Now, the Constitution does not explicitly mention the right to protest. That is why there have been various discussions, debates, cases and Supreme Court judgments that have been interpreted with regards to time, right? So there have been various confrontations between the rights of citizens and the government's power to dissent, the government's power to take immediate action that it has taken so far in many of the cases. So constitutional restrictions. What are those restrictions? As we all know that our fundamental rights, they are not absolute in nature, which means that there are certain reasonable restrictions that have been put on the fundamental rights, and these reasonable restrictions are on the grounds of to uphold the sovereignty and integrity of India, to protect the security of the state, to maintain public order, decency and morality, to maintain friendly relations with the foreign states, maintenance of public peace and order, protection of others' rights, and it should not hamper the contempt of the court. So these are certain restrictions that have been put on fundamental rights, and they are they reasonable in nature or not? Let's see. So when does a protest becomes illegal, right? When does government has to clamp down on the protesters? What situation arises basically? What is the catalyst or what is the reason? So firstly, a protest loses constitutional protection first when it turns violent or destructive, right? Second, it leads to rioting or mob violence, which we have seen thoda sa hua tha. Then it if it involves destruction of public property, if it blocks the essential public services or roads for indefinite time, then if it creates a threat to public safety and security. So there are certain Supreme Court cases and judgments thereby. The first case was Mazdoor Kisan Shakti Sangathan 2018. What had happened in this case? There were people who were protesting peacefully at Jantar Mantar. So what had happened in Mazdoor Kisan Shakti Sangathan? What had happened? The people who were protesting over there, and there were houses of people who were residing in the vicinity of the Jantar Mantar area. So those people, the households basically living in the vicinity of the area, they kind of filed a complaint to the government that due to noise pollution, they are not able to live peacefully. Now the government and the Supreme Court intervened, and it has to strike a balance between the people's fundamental right to protest and the people's right to live peacefully, right? So the Supreme Court observed that yes, people do have right to protest, however it should not infringe the rights of others, which is the right to live peacefully. If there is a pollution, if there was a noise pollution at that time in that particular area, so NGT National Green Tribunal, which takes care of not only the air pollution or water pollution but also the noise pollution, so thus it intervened and it suggested that we need to have a balance between citizens' right to protest and fellow citizens' right to live peacefully, right? So this was the judgment. The next case was Amit Sani versus Commissioner of Police, which is usually referred to as the Shaheen Bagh case of 2020. What had happened? The protesters, they had gathered at a place near Kalindi Kunj, and they have been protesting over there for a long time, which caused traffic congestion, and it had become inconvenient for the normal public to function. Therefore, the government intervened and it said that there should be certain dedicated places where the protest should be there. So the protesters, they had occupied Kalindi Kunj, so they were being moved from there, and the Supreme Court observed that there must be some dedicated places for protest. You cannot do protest for indefinite point of time, for indefinite time at any place, because it will alter the normal functioning of the state. It will do inconvenience to the citizens living over there. Then comes Anuradha Bhasin case. This case was surfaced after the removal of the Article 370 in Jammu Kashmir. Anuradha Bhasin, who was an executive editor of Kashmir Times basically, so she observed basically the right to internet was suspended in Jammu Kashmir for quite a long time. So she had to intervene that it is infringing her basic right, that is right to life. So the Supreme Court observed basically that the government basically cannot take away the fundamental rights of citizens for indefinite point of life, and right to internet in this digital age is very essential. The government cannot take away the right to knowledge or right to internet for indefinite point of time. So the livelihoods of many people were impacted, and the normal functioning was basically disrupted. So the government intervened that there has to be certain reasonable conditions when the government takes away the fundamental rights, and those necessary conditions are, first of all, the reasonability would be taken into account. Second, proportionality test should be there. Proportionality test means that the government's action should be in consonance with the severability of the act. The seriousness of the act basically has to balance with the government's action. Then only the government can take or suspend the fundamental rights for whichever long it wants to. Then what are the recent Supreme Court's observations with regards to this right? So police should not suppress peaceful protest through excessive force or arbitrary detention. It has to be reasonable. The immediate action that the government takes, it needs to be reasonable and rational. The state must facilitate, first of all, violence should never be the solution, and clamping down on the protesters should be the last resort. First of all, debates and discussions must be there between the government and the protesters. So the right to protest must balance with the rights of others and the need to maintain public order, right? So when does the protest becomes illegal? First of all, if it leads to violence or rioting or destruction of public property, blocking the essential public services, disrupting the normal functioning of the state, then when it becomes threat to public safety and serious disturbance to public order is there, so then the government becomes competitive, the authority becomes competitive to take relevant actions. Now you need to remember that peaceful protest is a constitutional right, and you need to also remember the principle of proportionality. This is important for your mains point of view. What do we mean by excessive policing? Excessive policing means when it tries to intervene in the normal protesting or normal exercising of fundamental rights of the citizens. That is called extreme policing or extreme moral policing by the government. So while maintaining law and order, it is the duty of the state. While maintaining law and order is the duty of the state, but excessive policing can violate the fundamental rights of the citizens and weaken democratic values, because fundamental rights form the basic fabric of democracy. You cannot take away under normal circumstances. The government should not suspend fundamental rights under normal circumstances, right? So what are the major concerns regarding this? First of all, there should not be arbitrary arrests and detentions. Whenever or wherever or the government likes, it can just detain the peaceful protesters. This should not be there. Then excessive use of force can lead to violence on both the sides. This should be avoided. There should not be blanket prohibitory orders. Blanket means पूरा protest cancel नहीं करना है. The entire protest must not be cancelled. However, regulations could be there. The government can ask the police to regulate the protest rather than ruling out the entire protest itself. Then internet shutdowns only during extraordinary circumstances must be there. You cannot deprive the citizens of basic information and knowledge during such time. Then criminalization of dissent, filing of FIRs and use of sedition, UAPA and other harsh laws. They should be used only as a last resort and not just for the normal protesters. So what is the solution regarding this? How can the government balance citizens' right and the government's SOP? There has to be clear SOPs for the police. They should have the clear-cut directions as to how to operate. There should not be dilution of, you can say, ethics, and there should not be a gray area for them. Then dialogue should be there before force, before violence. There should be proper debate and discussion between the protesters and the government. The government should and must facilitate a basic dialogue and listen to the demands of the protesters. And there has to be independent accountability of various authorities, the protesters as well, the government as well, and the judiciary. It should play its robust role here to look into the inquiries. Then use of technology like smart surveillance and body cameras for crowd management must be there. Then human rights based policing should be there, like training, sensationalization and respect for dignity of the protesters, like with regards to female rights, with regards to gender sensitivity. So these values must be incorporated, must be given prior to the police which have come to clamp down on the protesters. Now the question arises, what is a fair trial? So when equal treatment before the law is ensured, right? When opportunity to defend oneself, the accused is given the right to opportunity to defend himself, right? Then independent and impartial court is there, legal representation is given, and trial is based only on the admissible evidence. So why this news has been surfaced? Basically what had happened in 1996, there was an incident, there was a bomb blast in the bus wherein 14 people were being killed, and the accused, he was being sentenced a death penalty by a trial court which was upheld by high court. Then he filed a appeal in the Supreme Court that he was not given proper legal representation. So now he wanted the Supreme Court to intervene and to do the relevant justice. So the Supreme Court now upheld that no matter whoever the accused is, he must be given a fair trial and he must be represented by a legal representative. So, and this has been ensured and safeguarded by the Constitution as well. Like Article 14 itself says, equality before law should be there, protection in respect to conviction of offences must be there, that is with regards to criminal cases. Then Article 21 talks of right to life and personal liberty, which also includes right to fair trial and right to speedy trial, right? And Article 22 talks of the safeguards against arrest and detention. All these maybe not explicitly but implicitly talks of a fair trial must be given. Fair, just and reasonable trial must be given to the even the most accused. So he should also have the fundamental right. Now what challenges could be there in a fair trial? What all problems or issues could be there in the during the fundamental trial? So first of all, procedure lapses that are identified by the court, like for example, inadequate legal representation. If somebody is not provided with a lawyer or proper, he has not been represented in front of the court, so this could be one of the procedural lapses. Then improper examination of evidence, it can also happen. Violation of the due process of law rather than procedure established by law. Due process of law takes into account the wider interpretation of the morality, ethicality and fair and just trial of the court rather than just establishing the procedure established by law. Then if failure is due to mitigating circumstances, then unfair sentencing is there. So all these come under the definition of procedural lapses, which the Supreme Court observes if anything of this sort happens, then the accused must be given a fair chance to again re-represent himself, right? So what did the Supreme Court observe? That death penalty should be the last option and the extreme form of punishment which requires the highest standards of fairness, because our courts, they don't work like that. They don't give capital punishment or death penalty so easily. There has to be a proper way, then only, I mean, this is the last resort basically. So any serious procedural defeat can vitiate the conviction or the sentence, including the death penalty. Courts must ensure that the trial is not only fair but also seen to be fair. Justice hota dikhna bhi chahiye. Then the rights of the accused cannot be compromised under any circumstances. Even at the brink of the collapse, he must be given the right to be legally represented. Then justice must be based on the evidence, law and due process rather than procedure established by law. So this was about fair trial. What are the challenges and what the Supreme Court observed and why this was in news due to the 1996 wala case. Then there are certain cases related to the fair trial or speedy trial or fair justice with regards to this, like Husainara Khatun versus State of Bihar case that had held in 1979. So it observed, in this case, Supreme Court observed and gave its due judgment that right to speedy trial is an integral part of Article 21. So right to speedy trial means the under trials basically habeas corpus was used in this case, wherein there were several under trials that were put in front of the court and judiciary, and they were given their due justice under the umbrella of speedy trial. Then some other cases which further followed, like Zahira Sheikh versus State of Gujarat. Again, the same thing was reiterated, that fair trial is the foundation of criminal justice, and it does forms part of Article 21, which is the right to life. Then next case was Menaka Gandhi case, in which the due process of law was reiterated, and the government said that it should not be only procedure established by law, rather due process of law. That means the court, the judiciary must look into the morality of the law, the justness, the fairness, and the wider interpretation of the implementation of the law should be taken into account. Then recent Supreme Court judgment was the right to fair trial applies with equal force in the death penalty cases as well. So this was about right to fair trial. So how does our judiciary works? So we consider death penalty as in the rarest of rare cases, which was reiterated in the Bachchan Singh versus State of Punjab case, because we don't favor or we don't reiterate death penalty. It should be there in the rarest of rare and the rarest of rare and last resort for anything. So death penalty is constitutional but can be awarded only after following the strictest procedural safeguards to ensure fair trial and due process. If fair trial and due process have not been given, then the accused must be given the due representation. He must be given his fundamental right to be legally represented. So the challenges, you can have a look. Wrongful convictions must not be there, inconsistent sentencing must not be there, quality of legal aid should also be checked, and delay in justice. Justice delayed is justice denied. This has been usually observed. So why right to fair trial is a matter? Why is it important basically? So first of all, it strengthens the rule of law, which reinforces that nobody, even in the gravest crimes, everybody should be treated equal in the eyes of law. Then reinforces the due process, which was reiterated in Menaka Gandhi case, and due process over procedure established by law was furbished. Then it protects human rights, which safeguards dignity, liberty, and life under Article 21. And it prevents miscarriage of justice. That even during the last, or you can say final verdict has been given, still that person has the right to be represented by a legal representative, like since he had appealed in the Supreme Court. This improves the criminal justice system. So how can we proceed with that? What is the way forward? We should strengthen the legal aid, like we should ensure competent, early and effective legal representation to every accused. Improve investigation quality, better judicial training must be there, and uniform sentencing guidelines must be at force. Witness protection must be there if there is any witness. So faster but fair trials should be there at force. Now for prelims, there are certain articles that are important, like Article 14 deals with the equality before law, Article 20 deals with the protection with regards to conviction of offences, Article 21 deals with the right to life, 22 deals with the safeguards against arrest and detention, and Article 72, mercy petition to the president. Then Article 161, mercy petition to the governor. Rarest of rare doctrine was reiterated in the Bachchan Singh case. Fair trial is a part of Article 21, very important. And due process of law, reiterated in Menaka Gandhi case. Death penalty, constitutional but with strict safeguards. Now, National Anti-Doping Amendment Act. So, National Anti-Doping Amendment Organization, first of all, it was registered in India under Society Registration Act back then in 2005. Then in 2009, it became a full-fledged organization working. Then in 2022, we again adopted the act with certain amendments, and now in 2025 again we have come up with certain amendments which are in consonance with the WADA. WADA is the international agency which sets the guidelines for the anti-doping mechanism, right? So, Parliament passed the NADA Act, National Anti-Doping Amendment Act 2025. There are various changes or amendments. First of all, let's look at what is doping. Doping hota kya hai? It refers to the use of prohibited substances or methods to artificially enhance the performance of any sports person or athlete. So what do they do, or in what forms they are being consumed? They can be taken in the blood directly, they can be in the form of steroids also, hormonal injection can also be there. So they are basically referred to as performance enhancing drugs, right? What is the objective of this amendment? The changes that we have incorporated recently, what is the whole purpose behind them? So first of all, they will ensure fair competition among the athletes so that a level playing field is being created for everybody. Then for the welfare of the athletes and sports persons, then international compliance to WADA would be at place. Then clean sports ecosystem must be there. There should be fairness, there should be justness across the sports ecosystem, and credibility should also be reiterated in Indian sports. So it can be done when we introduce certain necessary changes. So what is the whole purpose, whole idea of the act? The act strengthens India's anti-doping regime while ensuring greater independence and compliance with the global standards that are given at world level. So WADA code, India's anti-doping system is now aligned with the World Anti-Doping Code, right? So National Anti-Doping, NADA. So what is the structure? First of all, it is a central autonomous body under the act. It plans, implements and coordinates the anti-doping programs basically. Then it conducts dope testing, investigations and intelligence. It undertakes athlete education and awareness. Then there is a board also, dedicated board, National Board for Anti-Doping in Sports. Purpose is almost similar only. The idea behind these amendments is same only, to ensure better quality standards, to ensure consonance and whether they are in adherence to the global standards or not. So these amendments will ensure better compliance with the global standards. So how the system works? First of all, testing is done, then investigation, and thereafter adjudication is there. There is a mechanism for appeal as well. The appeals go to National Anti-Doping Appeal Panel. Then what is the role of WADA? World Anti-Doping Agency. What does it do basically? So first of all, it frames World Anti-Doping Code, which are uniform to all the countries, publishes prohibited list of some substances and methods which should not be used during the sports. It sets the international standards for testing and laboratories, monitors the compliance of signatory countries also, and accredits the laboratories and certifies the results. These laboratories, they do the testing for various substances. So after the due amendments, these changes have been incorporated. The main idea or the whole purpose is that only, to have better compliance mechanism, to have better standards, to be in consonance with the World Anti-Doping Code. So this was the whole idea behind this. So I hope this is clear. Winding up the class.